All right, great. Well, thanks again, everyone, for attending today. As I said, my name is Mark Young. I'm the CEO and founder of My HR Counsel. I like to say the only on-demand, unlimited legal advisory subscription service in the nation, we believe. I want to first thank all the men and women who have served the U.S. Armed Forces, especially today on Veterans Day, a very important day. Thank you all for your service. We know today's topic is a hotbed of disagreement and confusion, anger, debate, and four-letter words and whatever else. And I want to just make sure that you know we respect everybody's opinions, political and otherwise. But with that said, My HR Counsel is and will remain a legal advisory firm. We're formed in a new business model, one where a flat monthly fee, a subscription for unlimited HR, employment, business, and benefit plan law is available. And I would say probably half of you are clients of ours and half aren't. And we would love to have you be part of the family here. Our goal today and otherwise really though is to provide efficient and effective legal advice with a side of cost containment, I would say. And that is to help our clients comply with the laws and rules that have been proposed or have been passed. So we'll try not to make this a political discussion, but instead focus on what we know about the vaccine mandate as it stands today and what our law firm believes is the best plan of action to reduce your risk of lawsuits and fines for the betterment of your company. So without further ado, let me introduce you to Britt Waterman, today's expert speaker. Britt is a rock star, flat out. She's one of our senior attorneys. She's in charge of organizing our herd of cats who do all of the legal advisory, and she does a great job with that in her leadership role. But most importantly, she's a tremendous attorney. She provides excellent legal advice efficiently in a manner in which, as small business, medium-sized businesses, you'll get an answer that you can actually do something with versus a 10-page dissertation that you have to then, sort of sift through and make a guess. So she's a tremendous speaker and does our webinars monthly, if not weekly, writes a lot of our blogs, and as I said, provides great legal advice to our clients. And she's a great friend, and I thank her for everything that she does. So with that, I'm going to send it over to Britt and take it away.
Great, thanks, Mark. So today we will be talking about the current vaccine mandate, or the OSHA ETS, and everything you need to know. Like Mark said, I'm Britt Waterman. I'm one of the senior attorneys at My HR Counsel. We've got kind of an agenda or a few topics that we're going to make sure that we hit today. All the high points of the ETS, who it applies to, who it doesn't apply to, what are the basics, what are the finer points, to help you get a handle on what your company needs to do to comply. So let's start out. What is the mandate? This isn't what I remember from Schoolhouse Rock. There's no bill sitting on Capitol Hill. Here, the vaccine mandate is not a law. So President Biden cannot make laws on his own. He has cabinet members. The Department of Labor is a cabinet position, the Department of Health and Human Services, and he can advise his cabinet, the departments, various departments, supervise regulatory agencies. So for example, so OSHA, FDA, EPA, CDC, these are all federal regulatory agencies that are part of the executive branch. The executive branch is the president. So if the president hears that people are dumping radioactive waste into the Great Lakes, he can go and give the EPA a heads up and say, hey, we want to make a rule that people don't do that anymore. And the EPA can make a rule that doesn't have to go through the legislature and have Congress take a vote on that. The EPA can make a rule and say no more dumping radioactive waste. The Secretary of Labor enforces OSHA. OSHA makes rules. OSHA can make you turn in your 300 or 300A logs without Congress passing a law to make you require you to do it. Regulatory agencies such as OSHA or the FDA or the EPA, their recourse for companies not following their rules is issuing fines. President Biden can't overstep his authority and go so far in ordering a rule that really should require legislative action. So there is, as we learned in high school civics class, there are checks and balances between the three branches of government, and they all have to work together. So this is really similar to what we saw with the mask mandates, although they were on a state level. So state legislatures weren't passing the mask mandates. They weren't making laws. They couldn't act fast enough. Some weren't even in session at the beginning of the pandemic. There was no guarantee of, how a majority would vote, whether it would get stuck in committee. So governors, who are the executive branch of the state, were issuing orders directing their regulatory agencies, so states, Secretary of Health or Department of Health, to make rules requiring people to wear masks. So that's how we got the mask mandates in states, very similar to how we've got the OSHA ETS here at the federal level. Later, legislative bodies, state legislators caught up, and they started making the laws prohibiting the mask mandates in response. So that's kind of the path between the executive and the legislative branch. So what is an ETS? So an ETS is an emergency temporary standard. So OSHA stands for both the Occupational Health and Safety Act, which is the name of the law, and the Occupational Health and Safety Administration, which is the regulatory body that enforces OSHA, the law. So when we say OSHA, sometimes we're talking about the law itself, sometimes we're talking about the agency that enforces it. So OSHA, the law, says that the secretary shall issue an ETS if there is a grave danger from exposure to substances or agents known to be toxic or physically harmful. OSHA has to show that there is a significant risk to make a permanent rule, and that has to go through the whole formal rulemaking process, which is similar to passing a law. It's a long process where they solicit comments and people send in comments and they discuss it in a committee. But in order to get an ETS, which is an emergency temporary standard, which doesn't go through the formal rulemaking process, but gets enacted immediately, they have to show more than just significant risk. To get an ETS, you have to show grave danger, which is a heightened standard, and you need grave danger to jump the gate and act immediately. One court has defined grave danger as permanent, incurable, fatal consequences to workers. So the ETS has to be affirmed if it's supported by substantial information in the record as a whole. So if there is evidence showing, yes, this is a grave danger and we can back it up by, these cases here with these results, these things that have happened to these people, then the ETS has to be affirmed. The ETS is a proposal for a permanent standard. OSHA, the law, says that the permanent standard must be finalized within 6 months. So with the ETS, they've got 6 months to figure out whether they're going to let it fade away or whether they're going to make this vaccine mandate a permanent thing. An example of a permanent rule responding to a biological hazard in the workplace, so something that would be similar to the COVID-19 mandate that is a permanent rule, would be the bloodborne pathogens standard, which requires employers to offer the hepatitis B vaccine. So that's something where OSHA saw a substantial risk and made a permanent rule. Most ETSs are responding to new knowledge about chemicals that have been used in the workplace for a long time. So all of a sudden they found out that benzene was causing people to have all kinds of medical problems, and immediately they stepped in with an ETS to stop it. So this is kind of unusual to have an ETS in response to something that's very new that we didn't know about. So how did OSHA determine that there was grave danger? So the fact that you can get COVID outside of work and that it's not exclusive to the workplace doesn't matter in this case. So workers have plenty of opportunities to contract COVID at work. They're exposed to coworkers, customers, clients, vendors. They can't necessarily isolate like they could if they were home or outside of work. So the fact that they could get COVID outside of work does not mean that it is not a workplace hazard. It's like bloodborne pathogens. You could certainly get hepatitis B or HIV outside of work, but if you work in a hospital, that's also a workplace risk of contracting one of those illnesses. OSHA sets sanitation standards. Yes, people go to the bathroom outside when they're camping, but that doesn't mean that OSHA can't say, hey, you need actual toilets for people in the workplace. So just because something can happen outside of work does not mean that there is not grave danger within the workplace. So there have to be adverse effects. There can't be fleeting effects. There is a case where a chemical caused people to have excessive salivation and perspiration and blurred vision. And OSHA said that that was fleeting effects. That was not enough, those symptoms to issue an ETS. Contrasted with COVID, which they're seeing hospital stays, ICU care, long-term complications. The courts generally will defer to OSHA when OSHA says that doing something or not doing something will save lives. With COVID, we can all look around and see kind of the effects of COVID. We've all heard about the Delta variant, that it's now more dominant, more transmissible, more dangerous. We all can see the news stories with the hospitals filling up and the reduction in the number of available beds because of COVID patients. We all know it's very contagious. Many people have become very sick and died. The country was locked down. So there is support for the fact that COVID is a grave danger to workers. Also, work areas are often poorly ventilated. They're not designed for people to stay 6 feet apart. So the work area, workspace itself OSHA has determined is a place of great danger because COVID is so serious and causes death or long-term or serious illness, and because of the Delta variant becoming more dominant and more dangerous, and because work areas just aren't conducive to protecting yourself from COVID the way that you could protect yourself in your home and isolate from a family member who had it. So first I want to talk about the healthcare ETS. So workers who are the healthcare ETS came out in June of 2021, and workers who are covered by the healthcare ETS are exempt from the vaccination and testing ETS. So most of what we're talking about today is the vaccination and testing ETS. That's what was announced in September, is vaccination and testing ETS. That's what applies to all employers of over 100 employees. But workers that are covered by this healthcare ETS are exempt from the new ETS requirements. So with the healthcare, so OSHA believes that workers following the healthcare ETS, which involves there's requirements for physical barriers, having a COVID-19 plan, masking, ventilation, screening, paid time off for vaccination. OSHA believes that healthcare ETS is already providing a full suite of protection. It's just not possible to implement everything that is implemented by the healthcare ETS at your average work site. So the things that they're setting up in hospitals, nursing homes, home health care agencies, settings where people with suspected or confirmed COVID-19 are being treated, the physical barriers, the changes to the ventilation, those things are just not, we're just not able to do those in every workplace. And so that's why OSHA has moved along and has come out with a new ETS that covers all workers, not just healthcare workers, but workers who are working in these settings only have to follow the healthcare ETS, which only involves masking, screening, and then these other workplace rules. So workers following the healthcare ETS do not need to add a vaccination mandate on top of what they are already doing. Also, OSHA has until December to make the healthcare ETS a permanent rule, so they could be waiting for that to run out and cover them with a vaccination mandate as well. If you are a staffing agency who sends temps to healthcare facilities that are covered by the healthcare ETS, you, the staffing agency, are not exempt under the healthcare ETS. You are not a healthcare facility. You are an office or what, whatever, wherever your employees come in and are recruited and fill out their onboarding paperwork and pick up their paychecks. You are an office with temporary workers as your employees. If you have more than 100 of those employees, the vaccination or masking and testing requirements of the new ETS are going to apply to you. If you send these temps who have been who are subject to the mandatory vaccine or mask and test rules, if you send them to a healthcare facility on an assignment, they will have to screen, distance, mask, follow the healthcare ETS rules while they are in a healthcare setting. So they have to be vaccinated or mask and test because they're your employees and you as a company are subject to the vaccination and testing ETS, but then they also have to follow the workplace rules. So the healthcare ETS applies to a setting. The vaccination and testing ETS applies to employees, I guess is maybe a way that you can try to think of the difference. The CMS interim rule. So this is another part of President Biden's mandate, his announcement back in September about mandatory vaccination. So this applies to all Medicare and Medicaid certified provider and supplier types, defined as facilities, that have to have a plan or a policy in place ensuring that all applicable staff are vaccinated against COVID-19. So this is applying to ambulatory surgery centers, home infusion therapy suppliers, rehabilitation agencies, hospices, hospitals, basically, facilities that take Medicare and Medicaid. This is a more strict rule. The requirement for individuals who work at a Medicare or Medicaid certified provider or supplier are subject to vaccination only. The employer does not have the option of a mask and test policy. It is a mandatory vaccination policy only. This is different from OSHA. This comes from the Department of Health and Human Services, which is a cabinet post, just like it is a department, just like the Department of Labor. The CMS is a regulatory agency, just like OSHA. OSHA made their own ETS. CMS has made their own ETS or interim rule through the same process, skipping the normal rulemaking process and issuing this emergency order. So the interim rule, this particular rule applies to anyone like I said, regulated under CMS health and safety standards. It doesn't mean every place that takes Medicaid. So a physician's office or a dental office would not be covered under this CMS interim rule. Even though your physician or your dentist takes Medicaid, um, a physician or dental office wouldn't be regulated under this rule because the Social Security Act didn't give CMS the authority to regulate physician and dental practices. It's complicated. But if you have a private dental practice, you are not covered by the healthcare ATS. You are not covered by the CMS interim rule. If your dental office has more than 100 employees, you're covered by the vaccination and testing ATS. If you have fewer than 100 employees, you may not be subject to any vaccination or testing requirements. If you're a dental office with 10 employees, you may not be subject to any mandates. You could be covered under the ETS or under a state mandate. Many states have their own healthcare related mandates for healthcare workers. You could be under a company mandate if you're associated with a larger group or associated with an insurance company that takes federal contracts. You could be covered that way. But as you can see, it's going to depend on what type of business you are and who covers you. Are you covered by the healthcare ATS? Are you covered by the CMS interim rule? It's kind of, you need to look at it like a flow chart and kind of check the boxes and see which one covers you. Accommodations are allowed, even though it's a vaccination only, no testing option. Accommodations will be allowed for religious or medical reasons under the CMS interim rule, but they are extremely strict about documenting a need for accommodation and balancing out the risks. So this is a much stricter standard as far as accommodations. This preempts any state law. So any state law applying to healthcare providers that are also a Medicare and Medicaid certified provider, the federal law is going to preempt the state law. So you listen to the federal law in this case as far as vaccination and accommodations. The FAR clause, it's the Federal Acquisition Regulation. Basically, this is the what's called the federal contractor mandate. Where this is for employees working on contracts that are subject to the federal acquisition regulation. So this is not an OSHA mandate, or this doesn't come this is not a rule made by a regulatory body like OSHA, where they say, you know, we govern you and we make rules that affect your business. And the FAR clause is something that it's actually how they require the vaccination and the masking and the physical distancing and the testing is actually through a clause in the contract. So the contract between the federal government and the employer has to contain a clause that requires the party contracting with the government, the employer that has the federal contract, to have a mandatory vaccination policy. So this is in new contracts awarded on or after November 14th, or in an ongoing contract if an extension is requested or an option is exercised. So this is there's a lot of confusion about you know, who is covered. Is it, you know, if we have a federal contract to build something, is it just the people who are doing the physical building? You know, what if we don't have a federal contract at the time? So I'll try to break it down. A covered contractor, someone who has to have this FAR clause in their contract, is any contractor or subcontractor at any tier who is a party to a contract with the federal government, all the way down to the tier where the subcontractor is just providing the product. So all the way down to the bottom rung of subcontractors have to have this mandatory vaccination clause in their contract. A covered contractor employee, so someone who's going to be subject to the requirements in this clause, is any employee of a covered contractor working on or in connection with the covered contract or in a covered contract workplace. So this means HR, legal services, billing, they're all going to be covered by the FAR clause if the employer has a federal contract. It's not just going to be the people doing the physical work. A covered contract workplace is a location controlled by a covered contractor at which a covered employee may be present. So, if you have a place where people pick up paychecks or they go to a garage to repair equipment, and you have employees who work in the field who aren't working on the federal contract, and they come to the office and pick up a paycheck, and there might be somebody there in the office who does work on the federal contract. If there's a chance that they're going to cross paths in a building, everybody's covered. Everybody's got to get vaccinated. There's no testing option with the FAR clause. It is also vaccine only with reasonable accommodations allowed for religion and disability, but again, very, very strict. If you don't currently have any federal contracts, but you have had some in the past, or you may have some in the future, when employees, if you're working on one now, your employees must be fully vaccinated by December 8th. Or if you don't have one and you get one in the future, they must be vaccinated by the first day of the period of performance on the contract. It takes 2 shots, 4 weeks apart, plus 2 weeks, 6 weeks for someone to become fully vaccinated. Are you going to wait to get a contract and then sit around waiting 6 weeks to start performing on it? No, if you contract with the federal government at any point, vaccinate now. Get your workers ready now, so that when you get that federal contract, you can be ready to start. Your workers will be compliant. Other people exempt for the ETS, people who don't report to a workplace where other people are there, people who work from home exclusively, people who work exclusively outside. That means no riding in each other's cars. That means outside only. If you have teleworkers who come into the office for meetings periodically, they must be following the ETS to come into the office. So either vaccinated or masking and testing. You can't, if you have a mandatory vaccine policy, you can't decide to call them in last minute. It takes 6 weeks for someone to become fully vaccinated. Usually this isn't a problem if you've got 100% remote workers who never ever come in. If you've got sometimes people who sometimes come in, think about this before you get to the point where you expect them to come in and they're not up to date, they're not fully vaccinated. So here are the basics. You must develop, implement, and enforce a written policy and discipline or terminate people who do not follow it. This cannot be informal or casual. You have to comply. You have to prove that you're complying. You have until December 5th to comply with everything except doing the actual vaccination or testing. So this is, again, if you've got 100 or more employees, you have to have a mandatory COVID vaccination policy or a policy allowing weekly testing and wearing a mask, or a policy allowing an option. There are record keeping requirements. There are employee notice requirements and removing positive employees. All of this needs to go in your policy, and you have until December 5th to write your policy and make it compliant. If you choose a mandatory vaccine policy, all of your employees, including new hires, must be fully vaccinated by January 4th, with the exception of people who receive a religious or medical exemption. Fully vaccinated under the ATS is considered 2 doses of Pfizer or Moderna or 1 of Johnson & Johnson plus 2 weeks. You have to notify your employees of this policy in simple language. It has to address all of the requirements of the ETS and the policy. You have to provide information about how vaccines are safe, effective, and beneficial. This is a separate document that you'll have to provide, and you can get this from OSHA. But saying that positive effects of vaccines, you have to have an anti-retaliation provision in your policy. You should have who the policy applies to, effective date of the policy, deadline to comply, procedures for compliance and enforcement. This is a great undertaking that you're going to have done by December 4th, is having this compliant policy. And OSHA is there to help you. They have template policies on their website, so you're not alone. And of course, at my HR Council, we can help you. If you are our client, we can help you draft a policy and make sure you're compliant. But these are the basics, and they've all got to go in your policy. What everyone has been wondering, how do we count to 100? All of your employees across all US locations. It is based on head count only. Anyone on payroll counts. It doesn't matter where they perform the work. If they are on paid leave, they are on your payroll. If they are a paid intern, they count. If they come in and work 2 hours a month, you count them. It's always a good time to assess worker status. Independent contractors do not count when you're counting to 100. However, if you're leaning on saying that you have less than 100 employees because you've got a bunch of independent contractors and they're all misclassified, OSHA and the IRS are both going to come after you. So make sure your workers are appropriately classified. A single corporate entity with multiple locations will count all of the employees at all of its locations together. So you don't count separately by location. If you are a company and you have a branch in this city and a branch in this city and a branch in this city, it's the total count of all of the employees together, not branch by branch. If you've got a traditional franchisee-franchisor relationship where each franchise is independently owned and operated, and the franchisor and franchisee are separate employers, the franchisor just counts their corporate employees. The franchisee just counts the employees of that individual franchise. So if in a traditional franchisee-franchisor relationship, they are considered separate and they count their employees separately. If you've got the same owner who has more than one franchise location, that person would, or company would, count all of their locations together, all of their franchises together. Related entities, so different companies with varying degrees of common ownership. If they use the same safety manual, if they have the same safety director, if they have one OSHA contact person, they would count as one company. If they're handling safety matters together, they are considered a single employer and they have to count all of their employees together. Don't split hairs here. If you know, if your companies with varying degrees of common ownership handle safety matters all together, or if you don't, and you know, OSHA's going to figure that out. You know, don't call your janitor safety manager for one of your entities so that now you can split them apart and count people separately. This, you know, be honest about this. Staffing agencies count their temps as their employees. The client companies do not count the temps. If you are a staffing agency with over 100 employees and you have an employee who's just going to do one assignment at a client with fewer than 100 employees, they still have to be vaccinated or tested because they fall under your head count. Even if they're doing one assignment, they're your employee and they fall under the ETS. Vaccination or testing and masking. If you're doing a mandatory vaccine policy with only a religious or medical exemption, the proof of vaccination and the record keeping requirements are going to apply. If you can have a mandatory vaccination policy and offer testing and masking as a choice for anyone who opts out for a number of reasons that you can make up and say not just religious or medical exemptions, but you can say we have a mandatory vaccine policy, and anyone who you know, believes in natural medicine or is afraid of needles or meets these other conditions can also opt out. This is so dangerous if you're setting up your own list of reasons for opting out and allowing some people to opt out and not others based on your made up list. Religious and medical exemptions are written in the law. If you're making calls about whose philosophies or fears or political beliefs are valid enough to let them out of vaccination, you're running the risk of discrimination claims there. I would say best practice is either to have a mandatory vaccination policy with only the exemption for religious and medical accommodations, or to have a testing and masking policy only. People who bring in proof of their vaccination don't have to mask and test, but you don't require it. Everybody else can mask and test. Religious and medical accommodations must be mask and test. So if you have a mandatory vaccine policy, somebody requests an accommodation, that accommodation has to be testing and masking. Unless there is a religious or medical reason why they also cannot test or wear a mask, I may start thinking undue hardship at that point. If they cannot be vaccinated, wear a mask, or get a COVID-19 test, I would really start to question at this point, but it's you go on a case-by-case basis. So but that is if you have mandatory vaccination and someone requests an accommodation, the accommodation does have to be masking and testing. Unless they can work from home. If you've got somebody who can do their job just as effectively from home and they have a religious objection to being vaccinated, you can have them work from home. That certainly can be an accommodation. But just moving their desk to another area is not enough. You do have to have them masking and testing if they're going to be in the workplace interacting with other people. Oops. So who bears the cost? Another one of the big questions that we're getting. So OSHA has determined that it is not appropriate to impose costs on employers associated with COVID-19 testing. OSHA only requires employers to cover the cost of the more protective option, which is vaccination. And vaccination is a no-cost option. OSHA does not believe that it is appropriate to impose costs on employers for employees who made an individual choice to pursue a less protective option. So vaccination is the most protective option. That's going to be the most effective at stopping the spread. That's what OSHA prefers. That's OSHA's number one choice. Masking and testing is number two. And if you choose number two, then you've just chosen, if you're an employee and you choose number two, you've just chosen to pay for your own masks and tests, because it's not your employer's fault that you did not choose option one. This goes for face coverings too. Surprisingly, I know OSHA's standard has always been employers pay for personal protective equipment. But in this case, again, because employees are choosing a less protective option, employers do not have to pay for face coverings for unvaccinated employees. The caveat here is that state law may differ. Your state may require you to pay for testing. Your state may require you to pay for time spent testing as work time. It's going to depend on your state law. So you have to make sure that you are consulting with counsel on the laws in your state, not just the federal law. Record keeping. You have to keep a copy of proof of vaccination of each employee, a roster of each employee's vaccination status, and every COVID-19 test result that you get from an employee. For record keeping, it is not enough just to see the proof of vaccination, just to see the card. You have to retain a copy for the ETS. Under the FAR clause, you don't, but for the ETS, you need to keep a copy. Attestation is sufficient proof for the ETS. So if someone signs a statement swearing that they are vaccinated, that is sufficient proof. Not for the FAR clause, oddly enough, but for the ETS, you have to retain a copy, but attestation is fine. The roster must indicate whether each of your employees are fully vaccinated, partially vaccinated, not fully vaccinated because of a religious or medical exemption, or not considered fully vaccinated because they have not provided you with proof of vaccination. So your roster must put each employee into one of those categories. All of this information is confidential medical records. It all must be in a confidential medical file, separate from the employee's personnel file. It should be accessible on a need-to-know basis only. Basically, should be in a locked file cabinet or uploaded in a password protected encrypted file that only HR has the ability to access. This shouldn't be accessible to others in your organization. You must preserve all of these records while the ETS is in effect. Thankfully, this is not subject to OSHA's employment plus 30 years rule. So this is just, you're just required to keep all this while the ETS is in effect. Although depending on whether the ETS is made permanent, that may change. But for now, hold on to all of this while the ETS is in effect. Although you must retain every test result, if someone notifies you that they are positive, you don't need to retain both the positive test result and an official notification of a positive test. If the positive test is work-related and you can prove that they got COVID at work, you may still have to report it on your Form 300. You still have to report work-related COVID hospitalizations and fatalities to OSHA. OSHA can show up or give you a call and demand the number of fully vaccinated employees and the total number of employees you have within 4 hours. You have to give that information to OSHA within 4 hours. An employee can request the number of fully vaccinated employees and the number of total employees, and you have to give an employee who requests that information by the next business day. So yes, if your employee wants to know how many people are fully vaccinated, you do have to tell your employees that. You obviously do not tell them who is and who isn't. You can just give them the number. I did talk about having a policy that complies with the ETS. OSHA can demand a copy of your policy in 4 hours. Like I said, don't be casual, don't be informal about this, because OSHA could call you up or send you an email and say, you've got 4 hours to send us a policy that is 100% compliant, or we're going to fine you. And you'll be scrambling during those 4 hours if you haven't planned ahead and consulted with counsel and made sure that you have a policy that's compliant. Employees can demand copies of their own test records, so a record of their past test results by the end of the next business day. So they can ask for that as well. Testing and removal. You must test it at least once every 7 days and provide documentation. Employees cannot self-administer the test unless they are observed by the pharmacist at Walgreens or a healthcare provider. If someone is masking and testing and is not vaccinated, you cannot let them in until they show you documentation of negative results. If someone is positive, you can't let them back until they receive a negative test result, meet the CDC return to work criteria, or receive permission to return from their healthcare provider. If an employee tests positive, you cannot require them to undergo testing within 90 days after the positive test because the likelihood of false positives in that period. You only have to remove a positive employee. You do not have to remove someone who has been exposed. No paid time off required for someone who tests positive unless there is paid time off for that under state or local laws, but there's no paid time off under the ETS for a positive test or for having COVID. Masking in a vehicle with another employee, face coverings the ETS has specific requirements for face coverings and how they are worn. You can remove them if you're in the office by yourself with the door closed. If you need to identify somebody by looking at their whole face, they can pull the mask down. If they're eating or drinking, that's also an exception. So when do you have to give an employee paid time off? Like I said, unless your state or locality requires it, you do not have to give them paid time off for a positive COVID result. But you are required to provide a reasonable amount of paid time off to get vaccinated. So that is up to 4 hours. So if an employee takes 4 hours to drive to the vaccination site and drive back, you do have to give them up to 4 hours of paid time off. You have to give employees up to 2 days of paid leave to recover from vaccine-related symptoms. You can't require your employee to use PTO to get vaccinated. You can require them to use sick leave only from recovery. If an employee chooses to get vaccinated when they're not working, you don't have to give them money for that. They didn't miss any work. You don't have to give them anything. If you have separate sick and vacation policies, you can make them use the sick leave to recover from symptoms. You cannot make them use the vacation leave to recover from symptoms. If you have PTO in one bucket, you can make them use that to recover from symptoms. You can't make them go into the red on sick leave or PTO. So if they run out of PTO, you do still have to give them paid leave. You can't make them go negative in their balance. Where do we stand today? You may have heard of the injunction. Generally, federal rules and laws preempt state rules and laws. So some states made laws against vaccination mandates, and then OSHA came in. That's the federal government. They said, no, we're going to have the ETS. We're going to mandate vaccines. So sorry, states, we preempt your laws. We overrule your laws, and too bad, you have to obey the feds. A state cannot make a rule or a law giving employees less protection than they receive under the federal government. So a state could not issue its own law with more lax OSHA requirements. A state could not have its own OSHA agency and say, you know what, our rule is that you don't have to lock out, tag out, or you can't give them less protection than they get under the federal law. So right now, the 26 states have sued the federal government. The Fifth Circuit Court of Appeals, which is I believe four states, has granted a temporary injunction against the ETS. And the Department of Labor filed a responsive brief to that injunction, which means that this will go to court. The injunction does not mean that the ETS is gone forever. It means that it is not being enforced right now. But because we are not at the compliance deadline yet, the fact that it is not being enforced now doesn't mean much for us right now because we weren't required to be doing anything right now yet anyways. So the fact that it's enjoined, it isn't stopping us from doing something that we necessarily needed to be doing right now. The cases will, all the states' cases will be consolidated into one. On or around November 16th, they'll draw a lottery to determine which appeals court in the country will hear the case. Only one court can hear it, so they'll pick one court for all the states to combine their cases into one. So they won't decide even what court will hear it until November 16th. So this is going to take a while before we have an answer. Ultimately, the case could end up at the Supreme Court. Based on case law, precedent, previous ETSs, everything that OSHA has laid out in terms of grave danger, and I've read the entire ETS. It is very, very, very many pages long. And based on everything that OSHA has considered and what is needed to protect workers and precedent, the ETS has a good chance of standing. The Department of Labor has a good chance of defeating the temporary injunction, just based on precedent. So if the Federal Appeals Court has to follow what is current good law, they will uphold the ETS. That does not mean that judicial activism does not currently exist, and it doesn't mean that an appeals court judge could not find a reason to strike out on his own or her own and enjoin it permanently. Then if that happens, it's up to what the Supreme Court says. Again, OSHA has precedent on their side, but there are no guarantees. So we just, again, I can't tell you what's going to happen because I mean, we just don't know who's going to go rogue and who's going to say, you know what, that old law doesn't apply anymore, and we're going to do something different. We're going to overturn that, and this is the new law. That certainly can happen. Your state may have more restrictions than the ETS or the FAR clause. Your state may mandate vaccination for school employees, something like that. The injunction of the ETS doesn't mean that your state laws are enjoined or preempted. So your state laws would still be in effect. Like I said, a state can give employees more protection, not less. So the injunction, if your state vaccination requirements are stricter than the federal requirements, the injunction does not stop any of those state requirements. Will help you comply in your states. Like I said, states may be stricter, they may make employers pay for testing. We, as attorneys, as legal counsel, we can help you sort all that out and comply in your state. Our advice, where we stand right now, what are we telling our clients? Keep forging ahead in preparation for compliance. If the ETS is upheld, that December deadline and that January 4th deadline could still stand. And if you just drop it now and decide to roll the dice on what will happen, you could be nowhere near compliance at the time that you need to be. And that could result in fines if the ETS is upheld and January 4th rolls around and none of your employees are vaccinated and you've got no compliant policy. Put a lot of thought into how you're going to protect your workforce and stop the spread. You can certainly still implement a mandatory vaccination or a mask and test policy if there is no ETS, if you have fewer than 100 employees. If you're a healthcare employee and you want people to vaccinate as well as follow the healthcare ETS, you can certainly do that if that's what you feel is the best choice to protect your workforce. OSHA guidance still requires you to protect your most vulnerable worker under the general duty clause. So if you've got someone at work who's high risk and they also cannot be vaccinated for a medical reason, that person is at very high risk, and OSHA says you have to do everything you can to make sure that that very high risk worker does not get sick under the general duty clause. So you are obligated to take some action to protect your workers, whether there's an ETS requiring you all to vaccinate or whether there isn't. OSHA could still potentially find a way to fine you if your employees are getting COVID left and right because you're not requiring anybody to do anything. And you still have to comply in your state depending on your industry and state law factors. So that is the quick and dirty version of the ETS. I know that I have probably raised as many questions as I've answered, if not more. Like we said, I mean, certainly reach out. We will be sharing more information in the coming days. Sending out responses to questions. Unfortunately, we're out of time and we don't have time to respond to any questions in the chat. But thank you all for coming to the webinar today. I hope this has been helpful for you in terms of compliance. And again, if you are a client of ours, please reach out if this has raised any questions for you or if it failed to answer any questions for you. If you aren't a client, please visit myhrcouncil.com and see how we can help you comply with the ETS and also with any state and local laws that might affect you as well. So thank you all for coming. I hope you all enjoy the rest of your day.